Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book from Oxford University Press. It's this book here. You can actually see a picture of it. It's green. It's a thin paperback. I haven't physically got it with me. The title of the book is Privacy and Freedom of Expression by Richard Clayton and Hugh Tomlinson. It's in a second edition, in fact, and it's part of a reprint from the much larger work they've written called The Law of Human Rights. It's an important work in its own way, because obviously both privacy and freedom of expression very much part and parcel of the Human Rights Act itself, and subject to massive amounts of controversy, certainly with gagging orders concerning private lives of footballers and so forth. But you've got a much wider picture here involving how far can the media go before you have to say there has to be some privacy. Now that's really the issue. So we've given it a title. My wife and I, Elizabeth, my wife and I, have written a review, and we said, can a balance be struck between privacy and freedom of information? Freedom of expression. Now, the question that we really ask here is looked at and dealt with to a limited extent, because we say that this is an indispensable volume for your law library, and it's very handy to carry around because it's actually a paperback. This volume, of course, is a reprint of the chapters on privacy and freedom of expression from the second edition of the author's The Law of Human Rights. And as the erudite authors point out, privacy and freedom of expression were two of the most important rights introduced into English law by the Human Rights Act 1998, the old HRA, and add that the question of the balancing of these two rights has been central to the development of the new law of privacy and increasingly influencing the development of the English law of defamation. And obviously, for many of you as law students who perhaps go back a little way now, you'll remember the basic principles of definition and how we seem to have moved on a little bit, apart from the fact that it costs a fortune to issue proceedings. Now, the aim of this volume, therefore, is to provide a comprehensive and systematic treatment of human rights law and practice in the United Kingdom in relation to the often controversial areas of freedom and expression and privacy. As I said, all sort of wrapped up together, and it's that balance we're seeking. It's very interesting, too, to note to practitioners and non-practitioners alike that many people often have strong views one way or the other in this area. And as I say, it's one of those problems which are not very much where we'll get a final decision on one way or the other, because there is that balance to be sought. There are some out there who believe so passionately in the right to privacy that they would practically call for a ban on freedom of speech, if only a selective one. That seems to be happening, possibly with some of the gagging orders. This is difficult, of course, to stomach for those of us who would certainly come down with a galloping gulp and guilt feelings at the very thought of supporting any erosion of this hard-won freedom, still only a dream in certain countries, which Shakespeare would have described as less happier lands, where one unwise word spoken or written can have unspeakably dire consequences, and I'm sure we all know where those jurisdictions are. Why anybody should want to erode a freedom that others envy is beyond us, despite all the myriad yelps for privacy, some of them quite justified, though. We must admit, in this age of the ever-powerful telephoto lens, there are going to be problems, and this is where the book comes in. So if you're a practitioner in this field, particularly media law, this book, in our view, provides a detailed and thorough treatment of the law relating to human rights, privacy and freedom of expression in the UK. As human rights legislation continues to be tested out in the courts, the book therefore contains detailed coverage of the latest developments. To say this masterful and authoritative book is essential for your practice is an understatement. Thank you, OUP, and thank you to Clayton and Tomlinson. It's great to have just the reprint of this particular part of the bigger book. Thank you so much. Bye-bye.